Welcome to the YouTube lecture series, The Concepts and Rules in Evidence. My name is Professor Wes Porter. Today we're talking about one of the first rules that you should ever consider, one of the first evidentiary objections that you should always consider as the opponent, and that's relevance, and specifically Federal Rule of Evidence 4. I want you to think about all the rules of evidence as hurdles or speed bumps or detours as the opponent that you can put in the way of the proponent's presentation. The proponent wants to put on evidence. They want to present their evidence in the way they planned. It is for the opponent, it is the burden of the opponent to get in the way and patrol what is appropriate for the jury's ears and what's appropriate for their consideration and deliberation. What evidence should come in at trial and what should stay out based on the objections and based on the rules. If we're talking about relevance, though, we're really talking about this first hurdle, this hurdle that's right in front of us, because all evidence, any bit of evidence, any question at trial from an attorney, any prospective answer from a witness at trial, any document or exhibit that's going to be admitted at trial, it all has to be relevant. It has to get over that first hurdle, and that's probably one of the ones that we would call a speed bump for the reasons discussed. Here's some of those questions that I talk about how I organize my course, and you see some of those beginning questions that we talk about in other videos. Where are we? What is the proponent trying to do? What is the evidence? Those are things that we should always think about. Where are we? We're in federal court. We're at trial. Okay, the rules apply. What is the proponent trying to do? It looks like he's trying to ask this question of a witness, or it looks like he or she's trying to put in this document at evidence at trial. So we got to consider what is the evidence and what are they trying to prove with that evidence. And there you see, as we start to go into the substantive rules, is the evidence relevant? I put this when I get to the rules as my first hurdle, as the first speed bump. All evidence has to clear it. Here's the rule, even though it's set forth in 401 and 402. 402 is a meaningless rule. It says relevant evidence is admissible, irrelevant evidence is not. 401 is the one that gives us the test, and this is the test. Evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And that fact, that thing it goes to, is of consequence in determining the action. So we're going to talk about this, but you can see the language in red. Some parts of this rule offer us operative language. And when I say operative language, this is the part of the rule that we need to take and make part of our advocacy, make part of our evidentiary discussions when we are an opponent objecting under relevance, if we're the one standing in court and saying objection, irrelevant, or whether we're the proponent, we're the one putting on evidence, we're the one presenting evidence, and our opponent stood up and said objection, irrelevant. We're going to use this rule to offer our response. So this rule and our language in this rule in red, that's the stuff that we use to make arguments, to convince judges to go our way, to agree with us, and either overrule or sustain an objection, depending on our perspective. Talk about relevance as a relational analysis. Really what you're trying to do is you're trying to say whatever the proponent's trying to do, it has to go to something that matters. Whatever piece of evidence you're trying to either admit, or whatever testimony you're trying to elicit from a witness, whatever question you're asking in cross-examination, whatever that evidence is, whatever you're trying to do, and you should know what you're trying to do at all times. That's why relevance is an important rule. You should know why you're asking the question. You should know why you're trying to admit the document. What you as proponent are trying to prove has to connect at something that matters. And just this relational analysis, like 6th degree of Kevin Bacon, you just have to do the hard work of connecting person on the left to person on the right. I'll let you do that in your own time, but how can you connect Bernie Madoff 6 degrees to Kevin Bacon? It can be done, and it can be done through Bernie's fraud scheme all the way to Kevin Bacon's analysis. What is the proponent trying to do connecting to something that matters? That's why for trial, I advise new lawyers and law students that if you get an objection relevance, the first words out of your mouth can be in response as proponent. The first words out of your mouth can be, this goes to. You are saying to the judge, this evidence, what I'm trying to do, what I'm trying to prove, goes to, that is, it relates to, and then offer something that matters at trial. This goes to impeachment. This goes to the witness's credibility. This goes to an element of the crime. This goes to a part of the defense. This goes to, and then offered something that matters. The shorthand version of how to respond to relevance, this goes to something. Again, remember those perspectives. Remember the side of the case. The proponent, you're the one putting it on. Every question you ask, every exhibit that you intend to put in, every bit of testimony that you plan to elicit from the witness, you better be able to articulate, if challenged by the opponent, their burden to object. You better be able to articulate as proponent, why am I entitled to do this? What am I trying to prove with this question, and why does it connect to something that matters? It's a low hurdle. It's a speed bump of a hurdle, right? While people can object under relevance, it's never going to be the best objection. Why? Because look at how they wrote it up. It's any tendency. And it's not any tendency to make it more probable than not, or just more probable. That's how people mess up this rule. It's any tendency to make it more probable than it would be without this evidence. Are we better for having the evidence than if we didn't? That's it. That's what you're arguing. Are we better because we have this evidence than we would be without it? And what is it going to make a fact? Well, that a fact in the second line there, to make a fact, you have to argue that that fact matters in this trial, is of consequence in this trial. Credibility matters. Of course, elements of the crime matter. Certainly elements of the defense matter. But sometimes, think about it, anything can matter, can be of consequence. Don't make too much of B, this of consequence in determining the action. It's really, does it matter at trial? Can you make an argument that has any tendency to make something that matters at trial more or less probable than without that evidence? From that perspective, if I'm the proponent, putting it on, somebody dares objection irrelevant to my evidence, I'm arguing that it has some tendency to make something at this trial, something that matters, witness credibility, an element, anything else. I'm arguing that it has some tendency to make it more probable than it would be if we didn't have this evidence. I'm using the operative rules, I'm using the language in the rules to make my argument. If I'm the opponent, the one that had the duty to object, the one that stands in opposition, then I'm also using those same rules. I want to say that it has no tendency to make any fact that matters more or less probable than without that evidence. We're using the same rules, but we're spinning them and using them for our purposes. Here's some things to keep in mind with relevance. Nothing's inherently relevant. It's only relevant as it relates to this case, as it relates to what the claim or crime or defense is in this case. No inherent relevance. It's just as it relates. This goes to something. This is a very liberal standard. This is a speed bump that favors admissibility. It's a very liberal standard. And you got to think that almost under this rule, everything, if you can articulate anything as to why it's relevant, some tendency, you should presume that it's coming in with this being the only hurdle, with this being the only speed bump in the way. There's a relation to substantive law, but it's not that relevant evidence has to prove the case. It's not that it has to meet an element. It's not that it has to meet a defense. It's any fact that matters. A witness drinking at lunch in between a recess, that can matter. Why? Because witness credibility matters, and drinking can affect credibility. 6 degrees of Kevin Bacon, I can get witnesses drinking, which we didn't know about when the case started. It's not an element, it's not a defense, but the fact that leads to something that's at issue. Credibility is certainly at issue, and a witness's drinking can become a fact at issue at trial. And that's the same thing as with this last comment, bricks in a wall. It says they develop into issues and change during trial. Remember relevance, remember the first hurdle, and remember it as it's all about arguments from both sides using the operative language.